further discussion later on.
I know.
Where,
Listen, I'm going to let you ask that question, but you're really asking. I mean, I've been sitting here and she's not objecting. You're really asking for a lot of hearsay both ways.
this one is hearsay? Okay.
Well, yeah, if he's saying, he's repeating what she said, it's out there.
Oh, he's saying that's his statement.
It's out there.
It's out there. Like to characterize.
Ask this question, but I'm
Yes.
just telling you, you're going through a lot of hearsay.
Okay, Your Honor. Card.
Objection, Your
And-
Honor. Asked and answered.
Yeah, I think it is.
It's a different question.
Wow.
There's a purpose to this last question, if you let me ask it.
Objection, Your Honor. Asked and answered.
Sustain.
I think I've made the point. She referred, yes, Your Honor, multiple times. Now,
Objection, hearsay,
all right.
Your Honor.
This is actually a prior inconsistent statement because I asked Mrs. Scotterossi these questions. And
So you're just saying you're going to use it for impeachment?
correct, Your Honor. Yes.
Overruled. But you are asking a lot of hearsay questions.
Well, these are all,
They're not all inconsistent statements, so I'll.
well, the record will bear that out, but I'll make my argument to the court at the appropriate time.
Objection, that calls for a legal conclusion.
Any response to that?
What's that?
She said that calls for a legal conclusion.
I don't know that it does, but I'm asking for the officer's assessment. So,
He's not a lawyer. I'm going to ask you to move on.
Okay.
Sustain the objection. If you answered that, I'm striking it.
who owned the company when she interviewed
Objection,
you?
Your Honor. All of this is irrelevant at this point, whether he did the law research and whether or not
Well,
she had
he's
spoken
already
about the
testified
business.
that he doesn't remember whether she said she owned it, he owned it, or they both owned it.
And I'm asking whether he did anything to determine whether or not
You
she
already
misrepresented
answered
that.
But then you said something about lying. Repeat your last question.
Certainly. He said, you didn't do anything to determine whether Mrs. Scotterossi was lying or misrepresenting her role in that company, did you? That's my question.
Okay, but he doesn't remember what she said. So I'm gonna ask you to move on.
Okay.
That's not a proper question.
Okay, Your Honor. What did she say about his laptop?
Your
I don't
Honor,
recall.
Objection, irrelevant.
Well, it goes to it's impeachment again. Goes to prior inconsistent statement.
Well, you've got to be more specific.
I'll be more specific. She never even
Well, I'm
mentioned,
asking you to be more specific with what statement that's.
Oh, sure.
mentioned.
sure.
What she never denied that she.
You know what? I'll withdraw and I'll rephrase it to make it easier. Jargon, like it's out there.
Objection, Your Honor. None of this is relevant.
I disagree. He's investigating the case and I'm going to lead up to the point. I'll make my offer of proof.
Go ahead.
Objection, speculation, Your Honor.
Well,
That's fair.
that's
I'll
not
withdraw.
speculation, but it's argumentative.
I'll withdraw. Right?
Are you asking me?
Yeah, I'm asking you. I mean, spyware being on her computer.
Objection, Your Honor. Calls for hearsay.
I'll withdraw. Searching for financial data in the course of her separation from her husband.
Objection, Your Honor. That calls for speculation.
I'm asking, how does he know?
That calls for speculation. It's not relevant.
Okay. Mr. Scotterossi's claim that she had taken the money.
I know, but you're still talking about hearsay.
What's the
How is that?
I'm asking if he did anything to corroborate.
Mr. Scotterossi, you're referring to statements that Mr. Scotterossi's made, right?
I'm past that. I'm now referring to
Yeah, I know,
whether
but you-
an investigation, did he actually conduct any investigation? Didn't search her pockets, didn't search her vehicle, didn't search Mrs. Scotterossi's purse. Did you search any of those things?
Wait a minute.
Yeah.
You're really filling this thing with hearsay. I'm not saying anything. The prosecutor isn't objecting. When you're asking him about statements that he makes, unless there's an exception, it's hearsay. If you're asking what your client stated, unless it's admission against interest, and I know you're too good to ask those kinds of questions, it's hearsay unless you have an exception. I'm just asking you to move on. Okay?
Okay, I'm not dealing with hearsay here, Your Honor.
Well, you've been dealing with hearsay. If you haven't asked at least 20 questions that call for hearsay in the last 35, then I don't know what I'm doing.
Well, I beg to differ, but I'll.
Ask your next question.
Sure.
We'll take it one at a time.
Correct.
What my point is, who reported that the money was missing?
I hadn't asked that question.
Yeah, you did.
No, I didn't.
You said you didn't check for the money that Mr. that was reported stolen? Reportedly stolen. So where did that come from? It had to come from somebody. He wasn't there. There's no evidence he saw it on the camera. Somebody had to ask the question. Somebody had to make the statement. And it's hearsay, or it's a lack of foundation, or both. Okay? Can we move on?
She wasn't searched. Her vehicle wasn't searched.
I don't remember hearing her ever say that there was, the only time I ever heard anything about anybody saying that there was an accusation of money being stolen was that she reported that when she was testifying, that that's what your client said. You stole my effing money is what she testified to, as I recall it, which would be deemed an admission, right? It's against his interest. It's not in support of his interest.
It's against his interest to claim that she stole his money?
I'm saying that there was a reason why you're not going to object to hearsay. That is not hearsay. If the prosecutor's introducing that statement, as she did on direct, that's not hearsay.
Pat her down? Did you look? Did you examine her? There were conversations about the money and the gun.
Why don't you ask the next question? And we'll go from there. Go ahead. Ask your next question. And check for the spyware. He didn't go and search for the gun. He didn't investigate whether or not money was stolen.
What's the reason? For purposes of the case,
because you're saying it goes to her credibility. I get all that. I'm just saying you've established all of that, don't you think? I mean, which aspect of that have you established?
I hope so.
Okay.
I hope we've established it.
She held up her arm like this.
And describe for me what you're doing right now.
I'm holding a fist where I was assuming that she was showing how he was motioning with the firearm in his hand.
Judge, just for the record, because we can't see.
Yeah, you have to describe it. So you've got a closed fist somewhere about 3, 4. God, I don't want to put words in your mouth.
I'm just saying
I want you to tell me.
He's in the middle of this.
I don't want him to say it. I don't want me to.
There's absolutely no evidence whatsoever that what she says took place. There's no evidence that he pulled the gun. There's no evidence that he displayed the gun. There's no evidence that he brandished the gun. See in the kitchen, there's no evidence of a gun on the counter. And the police didn't search Mrs. Scadarrasi for it. The police and Mr. Scadarrasi, as we could tell, because Mr. Scadarrasi said this, there was some question later on. The police questioned her about where the gun was. But never did they actually do any kind of search for evidence in this case. And she then goes to the police department and it comes up with this story, for which there is not a single shred of evidence. No gun, no money, no wound, no injury. What do we have? We have Mrs. Scadarrasi's testimony. Did she act like a person who was trustworthy when she went to the house that day? Take a look at the video. Does an honest person enter into the home by disabling the exterior camera? No. Does a dishonest person traipse through? Does an honest person traipse through their landscaping? No. You could see, and she wanted to quibble with me over how she went about trying to remove the camera. You can see her up against the side of the wall trying to remove the camera, and then it's gone. We would see what happened inside if something had happened if she hadn't disabled the cameras. What a perfect ruse. Take my word for it. There's no evidence, but take my word for it. Even though I disabled the cameras that could have provided evidence of me leaving with the gun or not, as Mr. Scadarrasi claimed, leaving with the money or not, as Mr. Scadarrasi claimed, or this allegation of a violent assault or an allegation of an assault for which there's no evidence. We would see whether that occurred or not. And I asked the court to dismiss the case. Now, I reckon.
Your Honor, I'm not going to lecture you. I'll keep it short. But
You're not going to lecture me?
I didn't lecture you.
I really want to. And she testified truthfully the entire time. He claims that she was dishonest. She was very honest. And she said everything she did that night and why she did it. Any allegations of her incredibility are questions of fact to be heard at a trial.
Defendant is charged. We have 3 counts: felonious assault, felony firearm, and domestic violence. And this arises out of an incident which occurred on April the 10th, 2024 in Browns Township. And the scene of the alleged crime occurred at, was it 25801 Chelsea Creek Drive in Brownstown. Ms. Scottarossi indicated that she and the defendant, Mr. Scottarossi, separated a week earlier, and that she had at that time been living with her mother since she moved out. She had a key to the home and would come there in the morning and get the kids ready for school. There was a lot of testimony concerning the comings and goings of the victim in and out of the defendant's business and the residence that they occupied together until she'd left the week prior. After attempting to access codes from a computer at the defendant's business, which was named, I believe, Silver Touch Landscaping in Romulus, and she did have a key to that business. She then went to the residence again at 25801 Chelsea Creek in Brownstown. And I believe that the testimony was, and I think it's kind of confirmed here, my recollection was that it was sometime initially between 12 and 1 a.m. when she arrived at the business and then went over to the residence on Chelsea Creek. Sometime around 1 a.m. or whenever it was, early morning of April the 10th, she acknowledged that she did disable the security system, that she was secretive, and she gained access to his phone. She wanted to delete some spyware from her computer and believed she could do that if she could access the code in the defendant's phone. She drove to the Kroger parking lot after she entered the home and acquired the defendant's phone. And I believe the testimony was she wasn't able to access the code. She returned to the residence and was ultimately encountered by the defendant. She testified that after the defendant observed her, he walked to the end of a table and picked up his gun. I don't see anything in the video to corroborate that or to indicate that that is untruthful. She testified that at some point the defendant was about 15 feet away and he walked through a gate and came up to her, grabbed her in the back of her hair, and placed the pistol under her chin. That was the testimony. She had it pointed, and I specifically asked her, I believe, was the left side of her neck where she was just indicating that that was in court. She indicated that the gun was a 9mm Smith & Wesson and that the defendant had his finger on the trigger pointing it under her chin. That was the testimony again in court. She further testified that the defendant said, "Give me my effing money." I'm not going to state the whole word. To which she replied, "I don't have your money." According to the victim, the defendant stated, "I'm going to kill you." And the defendant stated, then stated, "You know who else I'm going to kill?" ? And according to the victim, the defendant looked at the kids' bedrooms and said, "Everyone." She testified that her response was something to the effect that, "You better hope so." The victim testified that she was scared and in fear for her life. The defendant then put the gun back, according to her, in his waistband, pretended he was going to punch her in the face, stopping 1 inch from her face. Their dog, a Rottweiler, then, she said, got excited and jumped on the defendant. Ms. Scottarossi then left the residence and drove to the Brownstown Police Department. I don't think there's any question but that there are a lot of inconsistencies in the testimony here. I mean, you could point out several inconsistencies in her testimony. Some of which may have been or may not have been deliberate. But two facts are clear. No matter how he had the gun pointed, if that's believed, that it would constitute a felonious assault. I don't care if he's pointing it at her neck with the barrel specifically pointing it at her, or if he's waving around the gun somewhere near her head and saying, I'm going to kill you. Again, all we need is an attempt to commit a battery or a reasonable apprehension by the victim to receive an immediate battery. And then you need an intent to make somebody reasonably fear an immediate battery. And third, also that the defendant had the ability, thought he had the ability, or appeared to have the ability to commit an assault, and fourth, that he used a dangerous weapon. So in my heart of hearts here, I'm very confident that I'm correct in binding over the defendant. There's certainly a fact question here. Credibility issues like this are going to be for the jury. A lot of what the defense points out may very well be persuasive to a jury, and whether the people can prove their case beyond a reasonable doubt is another issue. I will say, for the record, as long as we're talking about credibility, while I found some of her statements inconsistent, she is either one tremendous actress, or she appeared to be very credible to me, at least by her demeanor on the video when she was speaking to the police officer. So for those reasons, the court finds probable cause exists to believe that the crime of felonious assault was committed, as well as felony firearm. I'm going to bind the defendant over to the circuit court. The AOI date will be 2 weeks, 2 weeks from today, since the defendant is not in custody. And you do not object to the continuation of the bond, correct, counsel?
No objection, Your Honor.
So I'm going to go ahead and continue the bond. If everybody will just give me 1 minute, please. 3, 4, 3, 18, 3.